In 2011, after the Administrative Conference issued its recommendation, a petition for rulemaking was filed with the Office of the Federal Register, urging them to take bolder action than the Administrative Conference had taken on the issue of incorporation by reference. And the reason why the petition was filed with the Office of the Federal Register is that they are statutorily responsible for overseeing incorporation by reference in the Code of Federal Regulations. The Freedom of Information Act gives them that responsibility. And the petition that was filed with them asked them to define the statutory term reasonably available to require agencies to make sure that all of these materials were available for free online. And the question was, well, is this within the statutory mandate of the Office of the Federal Register? Can you interpret that provision of the statute to mean free online access? What can the Federal Register do to sort of move the ball forward on this question of access? Now, I won't go into the sort of technical interpretation of the statute. I think maybe the broader issues are where we should start here. The challenge for the Federal Register is that this is really a multidimensional problem. I mean, for one thing, incorporation by reference is of any material that's reasonably available to the class of persons affected thereby. It's not limited to standards, right? And it includes lots of things that aren't standards and that aren't private publications and that aren't copyrighted. And OFR's main statutory mandate is to create rules that can apply to all of these different kinds of materials that federal agencies need to incorporate by reference. Now, in addition, the Federal Register has statutory responsibility over the Federal Register and the Code of Federal Regulations, but it has no statutory responsibility over substantive regulation, which of course is various statutory mandates vested in various substantive regulatory agencies. It has no jurisdiction over federal standards policy. It can't decide to say that agencies no longer have to comply with the National Technology Transfer and Advancement Act, or OMB Circular A119. And so the challenge for the Office of the Federal Register when it was confronted with this petition was, well, what is the range of our statutory authority, and how do we respond to this petition in a way that sort of keeps us within our statutory mandate and doesn't tread into or create problems for other agencies that are charged with other parts of this multidimensional problem. And so I think a lot of folks, when the Office of the Federal Register eventually came out with regulations that largely tracked the Administrative Conference's recommendation. Some of the things that they did was they said, okay, in a preamble to a proposed or final rule, you have to explain to describe what the standard is. A lot of times these standards are very, very highly technical. I've read a lot of them, but I don't have an engineering degree, and frankly, I don't get a lot out of reading some of these standards because I don't have the necessary technical expertise to understand exactly what they mean or what the alternatives would be and those sorts of things. And so for someone like me, a description of the standard and what it does and how it fits into a regulation is actually potentially more useful and provides greater access and understanding of what the agency is doing and why than a bald copy of the standard with no explanation would provide. And so one of the things the Federal Register did to improve access, and this was a component of the Administrative Conference's recommendation, was to require agencies to explain what a standard does and why they're using it and how it fits into the regulation. And then they also required agencies in the preamble to explain what they were doing, what they had done to ensure that the materials incorporated by reference were reasonably available to the class of persons affected. So agencies now have to sort of account for in their preamble whether or not they've reached out to the standards developer and asked for read-only access during the rulemaking process or after the regulation is finalized. And you've seen a number of agencies since OFR changed its regulations begin to do this and to take, I think, more seriously a responsibility that prior to this was kind of invisible to them. They now have to take responsibility for, okay, what are the restrictions on access of these standards that were incorporated by reference? Have we reached out to the standards organization and asked them to put a read-only copy online? Are we sure that the people who really need access to the standard, including not only people who are directly required to comply with the regulations, but people who are interested or who are beneficiaries of those regulations, have we done what we can do to make sure that those people have access to the standards? And some people were disappointed that the Federal Register didn't go further. But to go further, they would have, I think, in my view, had more statutory jurisdiction than they presently have. Because again, you have issues of copyright. They can't change copyright. They have to comply with copyright. They can't change agency statutory missions. If an agency believes that in order to fulfill its statutory mandate, it needs to incorporate by reference a standard, even if it's not available, then that's a decision for that agency to make. It's not one that the Federal Register can really sort of reverse the agency on. And it can't change federal standards policy. So I think the Federal Register did what it could and did very well with a very limited ability to affect a small piece of a much larger puzzle. And in a way that moved the ball forward. And they did explicitly refer agencies to the incorporation by reference recommendation that had been adopted by ACUS. The regulations now point agencies toward that recommendation and urge them to comply with it. The handbook that the Office of the Federal Register provides to agencies to sort of flesh out their regulations, highlight the recommendation, and really help to support its implementation.